Hello, everybody, and welcome to Education Bite number 106, dated November 9th, 2020. I'm Walter, your mobile historian and blue-collar scholar. This Education Bite is entitled A Summary of Marbury versus Madison. Marbury versus Madison, for sure, is the preeminent case in U.S. constitutional law. It's a case that virtually all Americans have at least heard of, but many probably don't know anything about it other than the name itself. So what makes Marbury versus Madison so special among thousands of other cases decided by the U.S. Supreme Court? Well, in Marbury versus Madison, the Supreme Court of the United States first exercised its power of judicial review to invalidate part of an act of Congress, specifically Section 13 of the Judiciary Act of 1789. Section 13 had unconstitutionally expanded the U.S. Supreme Court's original jurisdiction, running directly against the clear language of the Constitution. Okay? That could not happen. All right? So what exactly occurred in the case of Marbury versus Madison? Well, William Marbury and a bunch of other guys had been appointed to federal judgeships in the very last waking days and hours of the Adams administration, okay? They'd been nominated and confirmed by the Senate. But unfortunately, all of their commissions had not been delivered before the expiration of Adams's term on March the 4th, 1801. And when the newly elected president, Thomas Jefferson, took office on the 4th of March, 1801, several of those commissions remained undelivered. Okay? As such, President Jefferson ordered his Secretary of State, James Madison, not to deliver any of the remaining commissions to these midnight judges, and they are referred to as such because they were appointed to their positions and confirmed virtually at the last minute before the Adams administration came to an end, hence midnight judges. All right? So Jefferson orders Madison not to deliver the commissions to their rightful owners. As such, Marbury and a few of his other fellow judges in waiting, as I like to say, filed suit at the Supreme Court of the United States, requesting a writ of mandamus, okay, which is a common law writ to order a public official to perform a duty that they, for some reason or another, are not performing. All right? The writ of mandamus is essentially saying to that public official, we command you to do something. All right? Now, Marbury initiated his suit under the Supreme Court's original jurisdiction as expanded via Section 13 of the Judiciary Act of 1789. Okay? Anybody see a problem with that so far? Yeah, me too. According to the Constitution, and as we've covered in previous videos, the Supreme Court's original jurisdiction is already set by the Constitution itself, and I'll read it again for you. It says, in all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, the Supreme Court shall have original jurisdiction. All right. And it goes further to say that in all the other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations as the Congress shall make. So, if the case at hand was not affecting ambassadors, other public ministers and consuls, and those in which a state shall be a party, then the court could not hear it under its original jurisdiction. It had to be heard via its appellate jurisdiction. So Section 13 of the Judiciary Act of 1789 expanded that constitutionally enumerated original jurisdiction to include issuing writs of mandamus in cases warranted by the principles and usages of law to any courts appointed or persons holding office under the authority of the United States. All right. So very clear language here in Article 3, Section 2 of the U.S. Constitution. So Marbury made his case to the Supreme Court. All right. And Chief Justice John Marshall, wasn't having it. All right. Marshall read the clear language of the Constitution versus Section 13 of the Judiciary Act of 1789 after he considered some of the following things. First and foremost, this could have gotten very ugly. Marbury was essentially asking the Supreme Court to issue a writ of mandamus to the Jefferson administration. Give the man his commission. Okay? Marshall knew quite well. Okay, he was no fool. Marshall had been a politician before he became Chief Justice. He knew how politics worked very well. And he knew that the Supreme Court at this point in its history was still a very weak and under-respected institution. Had he led the court, he and his fellow justices, to order the Jefferson administration to give Marbury his commission, Jefferson and Madison would have likely looked at the court like, yeah, okay, make us. So Marshall knew very well this wasn't the right course of action. Not only would the court have been ignored, but it would have also arguably suffered a great loss of already very low prestige. So Marshall did not do that. Another road to nowhere, quite simply, would have been simply telling Marbury that, even though you have the right to your commission, you didn't get it in time, so tough luck. That move would have been seen as kowtowing to the Jefferson administration, and that also would have resulted in the court suffering a loss of any trace elements of prestige. So Marshall chose what I like to say the safest and prestige-saving option. All right. Marshall, obviously, also in reading the clear language of the Constitution versus the Judiciary Act of 1789, held that essentially while Mr. Marbury was entitled to his commission, yes, he has been lawfully appointed and confirmed, so he's entitled to his commission, the Supreme Court wasn't the venue to order, all right, that it be delivered to him. Okay, it could not issue a writ of mandamus, quite simply because the Constitution, under its original jurisdiction, does not give the Supreme Court the power to issue writs of mandamus, okay? In no way, shape, or form. We just read it. That is not something that is included in that passage, okay? So, Mr. Marbury, being that he had initiated his case, okay, under an unconstitutional provision, Section 13 of the Judiciary Act of 1789, therefore lost his case, okay? Marshall conceded that he was entitled to the commission, but the Supreme Court was not the body to give it to him, to order it be given to him, okay? Marbury would have to go through another federal court, okay, to ask for that writ of mandamus, to order James Madison, Secretary of State, to give him his commission. James, give me my commission. I earned it, okay? And that writ of mandamus would have said, James, give Mr. Marbury his commission, okay? But, okay, going beyond just the mere technical facts of the case, Marshall also outlined great principles in constitutional law that still have effect and purpose to this day, okay? From Marbury versus Madison, Marshall, okay, held, obviously, within the language of his opinion, that laws, okay, which ran in conflict with the Constitution, were invalid and void. Okay? It is from Marbury versus Madison that we get the famous statement that it is emphatically the province and duty of the judicial department to say what the law is. Those who apply the rule to particular cases must of necessity expound and interpret that rule. If two laws conflict with each other, the courts must decide on the operation of each. And thus, no law in America can survive if it runs in direct conflict with the U.S. Constitution. Marshall made it quite clear that Congress could not alter the court's original jurisdiction by way of mere statute. If that was accepted in principle, then the Constitution is not worth the paper that it's written on, okay? Then the Constitution essentially might as well be, analogous to the unwritten Constitution in Britain, okay, which effectively can be changed by Parliament at any time. But that's not what we have here. We have a written Constitution in America, and Congress could not undermine it or directly write laws that are in complete contrast with the language of the Constitution. And when they did so, such laws were automatically invalid and void. End of story. Okay, so Section 13, okay, that language in Section 13 was ruled to be unconstitutional. And it was the first time in American history that the Supreme Court declared part of any act of Congress to be unconstitutional, okay? Lots of people up to that time questioned whether or not the Supreme Court even had such authority. But time would soon tell that not only did the court have that authority, okay, it was expected to use it when the Congress or the states clearly, okay, enacted laws or policies in general that ran in conflict with the U.S. Constitution. All right. So the bottom line of Marbury versus Madison essentially is that the courts, okay, have the power to declare, all right, and say what the meaning of the law is and whether or not the law runs in conflict with the U.S. Constitution. All right. If a law is enacted by the Congress or the states that runs in conflict with the language of the U.S. Constitution, that law must fall. It is automatically null, void, and unconstitutional. It cannot survive. It cannot stand. The Constitution of the United States is the paramount law in this nation, and no law enacted by the Congress, states, or any other entity can run contrary to its terms. End of story. Bottom line. That is why Marbury versus Madison is the preeminent case in American constitutional law. And that is why, folks, it set the tone for the exercise of judicial review from that point forward. Okay? So, any questions, controversies, please leave them down below and I'll be happy to answer them. Oh, and one more thing before I go. Guess who John Adams' Secretary of State was who failed to deliver Marbury's commission to him in a timely manner? None other than Chief Justice John Marshall. Indeed, Marshall was the very reason this was a case in the first place. But according to the judicial norms of the day, the mere fact that he was the Secretary of State who had failed to deliver Marbury's commission to him in time, leading Marbury to file suit in the Supreme Court to order that the commission be delivered by subsequent Secretary of State Madison, did not constitute a conflict of interest and thus prevent Marshall from presiding over the case. Just thought you'd like to know that. Times have changed and that would not be acceptable today, obviously. So, again, any questions, controversies, leave them down below and I'll be happy to answer them. And if you have not subscribed to my YouTube channel, I would graciously appreciate it if you did so. All support is wanted and very appreciated. Take care, stay safe out there, and I'll talk to you at the next History Bite. Peace.